We'll keep a very close eye on that flooding down in the Garden Route throughout the morning here on eNCA. Well, the High Court in Pretoria is going to hear the challenge to former President Jacob Zuma's medical parole today. It's being brought to court by the DA, AfriForum and the Helen Suzman Foundation. They want the parole reviewed and set aside. Let's just remind you what happened. Zuma was granted medical parole in September for his 2-year contempt sentence. Criminal law expert William Booth joining us. Hello to you, William. Always a pleasure. On what grounds is your understanding that this application has been brought forward?
Good morning, Gareth. Well, parole is governed by the Correctional Services Act, and there is actually a special section dealing with medical parole. And my understanding of that, and if you read the Act and previous cases, all save and except the Sheikh matter, that people who are released on medical parole are in a critical medical state. So the approach would be that the parole board's release of Mr. Zuma was incorrect, that they didn't apply their minds properly and look at the proper facts. So I'm not sure exactly what medical reports were submitted to the parole board, but the test is whether or not Mr. Zuma is in a critical situation medically for him to have been released.
So how much bearing will it have as well if we take a look at the situation regarding Arthur Fraser and his releasing of the former president? Do you believe that'll play into how the court is going to view this? Because as the person who was in charge and from my understanding could legally decide and make this decision, he made the decision. It just seems some people don't agree with him. How much weight will that carry in this court case, do you think, William?
Well, obviously it would carry weight, but as I've said, is the decision that was made of such a nature that the person making it applied their minds properly to all the facts, taking into consideration everything that was available. So obviously prisoners are entitled to be considered for release on parole. So the normal factors would be taken into account. If somebody has an address, they have a good support system, and let's say you receive a sentence of 15 months, a period of half of that sentence may have to have elapsed before, let's say, normal, usual parole is considered. So if the person is not a danger to society, that person could be considered for parole after having completed half of their sentence. But what happened here is the approach was from the medical aspect, and a much earlier date was determined than a period of 50% of Mr. Zuma's sentence. So the court will have to look at all the factors. And it's a bit difficult to prejudge the court's decision. We don't know exactly what aspects are being submitted and what will be counted by Mr. Zuma's lawyers.
One can imagine, though, William, that what DA leader John Steenhuisen has come out and said, and I just want to quote this just to give context to viewers, saying that, and I quote, on a proper interpretation of the Correctional Services Act, the Commissioner, in this case it was Arthur Fraser, is precluded from granting medical parole, going on to say as well that he believed in error that he was entitled to grant medical parole. This could also all come back down to, as you say, if the decision was legal or not. Is my understanding of that correct?
Yes, absolutely. So if the person who grants the parole board and or the commissioner or even the minister could intervene in situations of parole, has made a decision on the incorrect facts or has interpreted the law incorrectly, then obviously those are very strong grounds for review. So where we started earlier is medical parole is reserved for those people who are in a critical medical condition, where life expectancy is limited. And the sort of rationale behind it is that that person should be released back into their family, so they can be with their family, if they are expected to die in the near future. But, is that the fact with Mr. Zuma or not? Are those the grounds that were submitted? And if the Commissioner has decided incorrectly on interpretation of the Correctional Services Act, then those are excellent grounds for reviewing the decision to release on medical grounds. But again, if Zuma had waited a few more months, he probably would have been released on parole in any event.
Let's talk, if we could, in the last few seconds that I have with you, William. What does this mean if it is seen in court, the applicants that have come in there, it's ruled in their favour, and there is an order for the former president to return back to court? Is it as simple as him simply going back to prison, or could there be another fight on the cards, do you think? Last question to you.
Yes, no, look, if the order is that he must go back to serve the rest of his sentence, or such part of the sentence before, let's say, normal parole is considered, then he'd have to do that. But then again, he can appeal that decision. So he might have he has the opportunity to go to the Supreme Court of Appeal and or the Constitutional Court. So, you could still have a long process. We look at the history of Mr. Zuma's matters, every single one seems to go from one court to the other, and all the rulings have been pretty much against him. So I would say he's going to, if it goes against him, he's certainly going to follow the further process that he's entitled to do by way of further appeal and seeking redress, let's say, in a higher court than the Gauteng North High Court.
Always a pleasure speaking to you, making sense of it for people like me. Criminal law expert William Booth, what a pleasure. Thank you very much for joining us this morning. Former President Jacob Zuma's medical parole back in court today. We wait to see what happens, of course, the very latest as it develops here on eNCA.